When parents separate, typically their biggest concern is how the separation will affect the kids. Usually, both want what's best for their children, but sometimes they can have very different ideas about what that looks like.
Like most areas of separation divorce, it's always ideal if you can reach agreement on parenting arrangements yourselves, rather than leave it to the court to decide. While not always necessary, documenting your arrangements through a parenting agreement helps to give everyone involved certainty, especially in situations where there's conflict, ill will, or tension.
A parenting agreement is a legal document that sets out how you will share the care and parenting of your children. It will typically include specifics like who the children will live with, visitation schedules or the time the kids will spend with each parent, things like drop-off points, how and how often the children will communicate with the other parent when they're not with them, along with arrangements for things like birthdays, Christmas and school holidays, maintenance and financial support, the process required to change or alter plans, and a review date. Because as the kids get older and each of you move on with your lives, it's likely your arrangements will need to evolve.
If you and your ex aren't able to agree on these things, mediation and negotiation is your next step. In fact, mediation is typically a mandatory requirement for filing a parenting order application with the courts, unless of course it's unsafe to do so. In going into it, it's important to look at it as an opportunity rather than an obligation, because more often than not, it's in everyone's best interest for these matters to be resolved outside the courts.
Absolutely, but as we both know, it isn't always possible. If you aren't able to reach agreement through mediation, the next step is for your lawyer to file an application for parenting orders. This will require you both to attend court hearings and ultimately leave the decision in the hands of the courts.
Under Australian law, there is a presumption that it is in the best interest of the child for parents to share parental responsibility and have regular contact with the child. This doesn't mean, though, that the courts expect both parents to have equal time with the children, but rather they share responsibility for making decisions relating to the child.
That's right. At a practical level, it means the courts expect both parents to make a genuine effort to consult with each other in relation to major long-term issues and decisions relating to the children. This includes living arrangements, education, health, religion, medical treatment, and pretty much all other key decisions relating to the child's upbringing.
Typically, the only exception to this is in cases that involve high conflict, substance abuse, and/or family violence. In these instances, the court may award sole parental responsibility to one parent, but it's important to note that sole parental responsibility does not mean sole custody. Rather, it gives the parent sole responsibility for making decisions relating to the child.
If you're currently navigating a divorce or separation and need advice, our team is here to help. We have extensive experience in parenting matters and approach all matters with understanding, compassion, and professionalism.